and it's 9 o'clock, so we'll get started. Welcome to Statewide Disability Advisory Council virtual event. I'm Bobby Dutta. I co-chair SDAC. Please know that this meeting is being recorded for later broadcast through SDAC's YouTube channel. Before I proceed with the presentation, we have a few housekeeping rules for the virtual event. First, to avoid an echo, please be sure to mute speakers and microphone on one device if using multiple devices. If you do not hear the echo, then you're most likely the one that's causing the echo, so be mindful of that. And if you're not speaking or asking a question, mute your microphone. Ask questions using the chat function or raise your hand. Questions will be addressed in the order that they're received. To avoid reverb, please be sure to speak closely and quietly into the microphone. Thank you. And again, welcome to SDAC. Now, today we have a special presentation by CalHR. Representing CalHR are Glenna Wheeler and Eli Medrano. Glenna Wheeler is the chief at the CalHR Office of Civil Rights. Glenna has over 34 years of state service with over 20 years of experience in civil rights, equal employment opportunity. She is responsible for the statewide programs related to EEO, reasonable accommodation, which is an important topic for us, upward mobility, workforce analysis, bilingual services, and LEAP, limited exam and appointment program. She has also been a member of the Association of California State Employees with Disabilities. There are a few members here, board members from them, and has been a court-appointed special advocate for foster children. Very commendable. Now, Eli Medrano serves at CalHR's Office of Civil Rights as the statewide program consultant, EEO officer, reasonable accommodation, and upward mobility. His relevant state background includes his work as a reasonable accommodation coordinator, upward mobility coordinator, EEO officer, and business service office manager, quite a few positions. He said that he's grateful for the opportunity to work in an office that has EEO leadership and advocacy packaged so closely with every responsibility. So again, Eli and Glenna, welcome to SDAC, and please go ahead. The floor is yours.
Good morning. Thank you so much, Bobby, and thank you for inviting us back again. I know we talked at a recent meeting about the LEAP program specifically, and Eli is my colleague on reasonable accommodation on a daily basis, so we were excited to come and talk about reasonable accommodation as well. And we'll probably just bounce back and forth between the two of us. Sometimes we finish each other's sentences because we work on reasonable accommodation so much together. There are a couple of things that I thought we'd start out with. The first one is Jerry Gibbons, our colleague who normally attends all of the SDAC meetings to provide some LEAP statistics, is on a well-needed vacation today, and well-deserved, I should say. And he wanted us to let everyone know that there are currently 42 LEAP exams available, and the total number of LEAP hires this year is 71. So I didn't want to forget that since Jerry's not here today and he asked us to pass that on. Before we created our presentation and what we wanted to talk about, we did receive some questions. Thank you so much, Bobby, for sending us some questions in advance from the group. And a lot of the questions have to do with the recent passage of AB 313. Which is perfect because we were going to talk a lot about that in our presentation. but I want to make sure that we do address exactly what was asked from the membership. So I thought we'd start with those questions first. And then we'll add to that and tell you the additional things that we're doing, what we've been working on, what we're going to work on. But just wanted to make sure that we answer the questions from the membership and don't lose anything or miss anything there. So the first question was, we'd like to know when CalHR anticipates the release of the statewide model policy on reasonable accommodation. And this is something that's required by AB 313. And so that's a very popular question. We get that a lot since AB 313 has passed, because it's probably the most significant thing people are aware of and waiting for. And we've been, in all of our presentations so far, and based on our workload and what we're shooting for, we've been saying spring. So spring of this year, which is within the next couple of months. We've already been working on it, of course, but for something that to go out statewide, it does need to have quite a bit of review to be vetted. You know, we definitely want input from our stakeholders. And so some of you may remember that a couple of years ago, we did work on a reasonable accommodation policy, and that was mentioned in the question. It was just that one had been prepared previously. And that's true. CalHR did not have the same authority that we now have under AB 313. And that policy was designed based on what was requested from the joint project recommendations. If anyone remembers the joint project that went on back in 2015 and had about 100 recommendations related to people with disabilities. A lot of those have been implemented, and one of those was the policy. So we worked on that. The AB 313 language specifically says model policy. So it's a little bit different than what we were putting together before, which was kind of guidance on all kinds of areas of reasonable accommodation. So we're making sure that this model policy can really apply to all of the departments. I want to let Eli talk about this, because Eli has already put some preliminary work into reaching out to the departments to gauge where we are and see what's needed, and who's eager for that model policy or who needs it because they don't have a policy at all. So Eli, I'm going to pass it over to you just to give a little bit of information on that.
Okay, thank you. Thank you, Glenna. Good morning, Glenna. Good morning, Bobby. And SDAC, thank you for having us this morning. As Glenna shared with you, Glenn and I work closely together, especially in regard to EEO and the reasonable accommodation matters. So as soon as AB 313 passed, we immediately implemented efforts that we were in control of, or that we could immediately implement. So as I think it was December, no, not just I think, I'm sure it was December of last year, that we actually connected with all state agencies, departments, and commissions, and inquired with them in regard to the status of their reasonable accommodation policy. And we were actually quite pleased that 75% of the agencies we surveyed already have an existing reasonable accommodation policy. And we worked closly with the 25% that did not have a reasonable accommodation policy yet. And we check with them regularly, we bug them politely and professionally. And we're also very pleased to announce that as of February this year, only 12% do not have an RA policy yet. And the 12% of the state agencies are also actively working on their reasonable accommodation policy. So even if we have not released the statewide policy, we are already working closely with the departments, and they are committed in establishing a policy and are very conscientious in terms of developing them. So that's a quick update that I wanted to give in regard to the policy side.
Thank you so much, Eli. And if it helps to put it a little bit in context, some of those agencies that do not have a policy are so tiny. I don't think anyone realizes that we actually have some departments that are one person, two people, three people. And so when we contact them, they say, we've never had a reasonable accommodation in all the years we've existed. And we say, Well, that's great, but you still need a policy just in case you ever need to work on one or one is requested. That is something that's very common with all of our programs, where we find that departments are a little bit behind the 8 ball with, getting their policies together. It's usually those really, really tiny commissions, or they have so much turnover in those little 4 or 5 positions they have that there's not someone fully dedicated to EEO, reasonable accommodation. It's like one person wears all the hats. And so they usually deal with something only if it comes up. And so we're really trying to get the word out there to those little tiny agencies that we're here to help them, and that they should always have those policies available, whether they be discrimination complaint policies, sexual harassment prevention policies, or reasonable accommodation policies. They still should have those available for their employees. So just wanted to give that little bit of information so that everyone knows. We do spend some time talking to these agencies to find out why this is, and why, in my opinion, everyone should have had one since the 90s, but we do know that there are still those agencies out there that struggle a little bit. So Eli has just been spending a lot of time working with those agencies and making sure that they have everything they need. We do have a few that keep saying, well, we'll just wait for your model policy. We've waited this long. We'll wait for your model policy. And I kind of nudged Eli a little bit to not let them, stop working on it just because they're going to copy the model policy. I know some agencies will probably do that, but we really want them to give it some thought and take it seriously and work on it, and do what works for their agency as well, because there will be specific things related to their departments. So just wanted to add that. The second question we got was, we understand the governor's proposed budget contains 43 positions for CalHR to implement the California LEADS project. I would like to know how many of those proposed positions are allocated for the implementation of AB 313 legislation, as well as other activities previously authorized by statute. Especially interested in the projected staffing for the monitoring and oversight of departments' efforts to address long-term deficiencies in the employment of individuals with disabilities. And that question I was really excited about because it mentions several things that are super important to me that I've been working on. And CalHR did get some positions through the California LEADS Task Force for a variety of different things. The positions are spread throughout our department, from our exams unit to our personnel management division, our IT division, our workforce planning division. And so the focus that from the positions that CalHR received specifically related to disability and reasonable accommodation and other civil rights related matters, we really wanted to focus on compliance, because we feel like that's where we've been lacking in resources. And so we have, a workforce analysis every year where people turn in, all the departments turn in all of their disability information, their goals, they do the disability survey. All of that's been in place for years. But what has been lacking is what happens if the departments are kind of struggling in hiring people with disabilities. They're not reaching the goals that they're setting. And then they just set a new goal the next year. And so you're on a hamster wheel kind of, we're trying, but we're not reaching our goal, or we're not quite at the number we need to be. And so this is something that we've talked about in my office for many years now. And what we wanted were resources where we could follow up with departments after we get their data. So we're not just receiving their data and looking at it, we're actually analyzing that data and going back to them and saying, okay, we see what efforts you've made here. You've turned in your information, but you're still falling short on your disability goals. And so how can we help you with that? And wanting to make sure that we're holding departments accountable for things like using the LEAP list, for focused advertising, reaching out to organizations that can assist us in connecting with people with disabilities. So that kind of focused recruitment. And so these are the things where we want to go back. We need the staff and the resources to go back to those departments and see if they really truly are making the efforts that they're reporting to us. And if they are and they're just stuck, and for some reason they're having difficulty getting people with disabilities into their department, maybe we can explore why that is. Is that because, you know, it's a law enforcement agency that requires very specific, rigid requirements, and they're automatically ruling out people with disabilities in some way through their processes? Could it be other types of artificial barriers that they have within their hiring processes? And so it will give us the opportunity to dig deeper with those departments and find out exactly where the problems might lie, if there are any, or if they've really tried their best and there's just some unique things about their department, maybe we can be more creative with them, find similar departments that have been more successful, and see if there are some kind of think outside the box ways to reach out and get more people with disabilities to apply at that department. So Eli, I'm going to pass it to you just to see if there's anything you want to add to that one. But that's where, oh, I guess the most important part is we're looking at 2 positions to do that. So right now, you know, we don't have the positions yet. This would be in the, these are the ones that are approved, but they would come in July. And so we are in the process of creating the duty statements and the activities and things that we want these people to do, these new positions to do. And so these are the things we're focused on. The things that I mentioned are the things that we're focused on because we feel that's the part that's most lacking with our process now. And so we're going to dedicate a lot of the time from those 2 positions to that compliance piece. And I do want to mention, just because as part of that is written in the BCP, it's also connected to apprenticeships. And so the apprenticeships are under our workforce planning division. And we jointly work together to get these positions because the apprenticeships will be directly tied to upward mobility for people in low-paying positions, which often are people with disabilities, people of color, women. And so we have a significant upward mobility program, and the robust apprenticeship programs that they are building will be directly connected to our upward mobility program, so that we have the same staff crossing over, working on both of those things. And we're really excited about that. So that's another component that those 2 positions will cover. Eli, did you want to add anything on that?
I really just wanted to reiterate the exciting aspect of it, that we're so excited that the BCP got approved, and it's going to be great for our office, especially in terms of delivering services statewide, and for individuals working for the state as well. And in an ideal world, hiring new staff and implementing these new efforts would take overnight. However, it takes time. But as Glenna shared, we're all working together in terms of preparing the necessary documents and necessary processes that will eventually launch these programs. So in the meantime, also, we have the Reasonable Accommodation Roundtable, which we have on a quarterly basis. And through the RA Roundtable and other consultations too that we have with state professionals and EEO, reasonable accommodation, LEAP, and all other related matters, we connect closely with state professionals, and they could consult with us directly. So even if the monitoring, the EEO Academy is not in place yet, we have close connections with state departments who consult with us. But as I've said, it's an exciting time at CalHR, and particularly for our office, because we will be able to do those things that we previously just envisioned. And just to share a personal anecdote, when I started at CalHR, I asked Glenna, I was like, Glenna, is there going to be a robust training component in my role? And at that time, it was just a dream. And now that dream is in a way manifesting. So I'm very grateful and excited about that aspect of my job.
Thank you, Eli. It's also exciting to have someone as my colleague on and kind of co-worker on this who is just as excited about everything as I am. So Eli and I are often a little bit giddy when we see that we're going to get some support for doing some of this work. So that's something we've been talking about for a couple of years now, and it is an exciting time. It's a little bit overwhelming because it's a lot of work, but we have been begging for it, so we are ready for the challenge. The third and last question that we got was the state administrative manual refers to the statewide telework policy. The policy states that remote-centered teleworkers shall use a reasonable accommodation. Shall use a shared workstation when working in the office. The employees who have a reasonable accommodation in place at their workstation, how would common work area or hoteling address their accommodation needs? So that's a really great question as we are moving forward in this telework world that doesn't seem to be going away, and we're adapting to it a little bit more. And so absolutely, this idea of hoteling and shared workspace would come into play if there are employees who have reasonable accommodations that are related to their workspace and are unique to them. What we want to emphasize is that will not change in our view. That will not have any impact on the reasonable accommodations, because the reasonable accommodations still have to be effective and appropriate for the person's needs. So if that person needs a private workspace, they would still receive that as part of their reasonable accommodation. If they needed their own specific software, equipment, all of those things, we of course would make sure, or the departments should be making sure that everyone receives that. Sharing a workspace would only be an option if it doesn't in any way negatively impact the reasonable accommodation. So we don't see reasonable accommodation changing in the way that it's processed, in the way that it's implemented in the future due to these telework requirements. We have received a lot of feedback from people with disabilities who've indicated that they are appreciative of the option of teleworking. It's really assisted people with disabilities, especially when it comes to equipment and environment and workspace, because now they have much more control over that. And more time, just even to do work and to focus on work. That's true for all of us because they're not, having to commute in and out and things like that. And so we really want to emphasize, and we'll give consultation as we do every day. We give consultation every day to departments on reasonable accommodation, that this telework environment should not change the way that they implement their reasonable accommodations, and they still need to ensure that those are done on a very unique, individualized basis so that the employee gets exactly what they need to effectively perform the essential functions of the job. Eli, do you want to add anything on that one?
I do want to add that, the statewide telework policy was also released in October, the same month that AB 313 passed. So October last year was quite an eventful month. And along with that too, with NDEAM, being in the same month. So for the statewide telework policy, that was released through DGS, and that is also hosted by the Department of General Services. So if you would like more information in regard to the statewide telework policy, you could go to that document, and I could find a link to and provide it to everyone. But as Glenna shared with you, we are providing consultation to state professionals who manage the reasonable accommodation processes. And in fact, November last year, shortly after the release of the statewide telework policy, we actually dedicated our reasonable accommodation coordinator roundtable for the topic was telework as reasonable accommodation. So in that particular session, we delivered a presentation. We answered questions that state professionals who facilitate reasonable accommodation submitted. And we had a robust discussion in regard to things that were anticipated and also things that state reasonable accommodation professionals were already experiencing. And as Glenna shared, reasonable accommodation per se, the processes, the manner in which reasonable accommodation coordinators must engage in the interactive process, that part should not change. The law has not changed in that particular regard. And yes, we are faced with new circumstances, new challenges, but we always remind reasonable accommodation professionals that you must still engage in a timely, interactive process and engage in good faith. And there are resources that state reasonable accommodation professionals could utilize, and including us at CalHR to consult with us in regard to processing these RA requests. So a message that I'd like to deliver to everyone is, if you are anticipating any issues or if you have concerns, connect with your reasonable accommodation coordinator and prompt that conversation. And on many occasions too, your reasonable accommodation coordinator will re-engage in that interactive process with you, because they do want to make sure that your RA, your reasonable accommodation, is still working out, and to work out any issues. So work closely with your RA coordinators.
Thank you, Eli. There is just a couple of extra things that I want to add, and I do see questions in the chat. And I know we have some really great speakers for the rest of the meeting, and I don't want to take up too much time. We will make sure we note the questions just in case we don't have the chance online to answer them today. We can get back to everyone, and we could provide that to Bobby to get back to those individuals if that's the preference, because I do see some really great questions there. But something I just wanted to add is AB 313 does also require a report to be created that shows, the success of all of the things that AB 313 is requiring that we implement. And we've already been talking about that. It does say that the report is due from 2025 to 2029. So it's a very specific point of time so that data can be compared to see if things that have been implemented have been successful and effective. And what we're looking at right now is incorporating that into our annual census. If anyone's familiar with our annual census, it's a very comprehensive report. And it talks about LEAP, it talks about upward mobility, but it's all of the demographic data and very inclusive of all of the disability data representation from the departments. And so we're thinking that's a really good place to include the data that would come as a result of implementation of AB 313. And I do see a couple of hands up, including Ralph, who I actually worked with on our last reasonable accommodation policy. And so I want to make sure, Bobby, I want to defer to you if there's time to get to those people, or if you'd like us to get back to everyone later. I just don't want to take up too much time.
Thank you so much, Glenna. Are you finished with your presentation? I would like to open it up for folks to ask you questions, but I want to make sure that you're not rushed into answering anything and you're actually completed your segment.
Yes, I think the only thing that I would add, because Eli briefly mentioned it about EEO training, is that we are looking at a reasonable accommodation training class as well. We're actually working on a lot of civil rights EEO related classes, including investigator training and upward mobility training and LEAP training, all kinds of good stuff. But Eli and I are very focused on reasonable accommodation training because we know that that is something very specific that people who are new to evaluating reasonable accommodations, new reasonable accommodation coordinators, don't have a lot of guidance in that area. And so one thing that CalHR really wants to offer as part of our training cohort of classes is reasonable accommodation training. And like Eli said, it all can't happen overnight. We're kind of a tiny little office of, really just the two of us for reasonable accommodation. But because we have such a passion for it, we're really excited to get something comprehensive out there so that people who are new to reasonable accommodation don't have to figure out everything on their own and can look to us for guidance. And so we are developing a training program for that.
Thank you so much. That was a really informative presentation. We got a lot of information from you. We've got a date of when your model policy is going to be released in spring in a couple of months. So all of this is really good news for all of us. So thank you so much for excellent presentation. I have 3 people with their hands up, and I'm going to start with Ralph. Please unmute and ask the question.
Can you hear me?
Yes, we can. Go ahead.
Great. Hello, Glenna and Eli. It's really wonderful to hear the plans you're making to move these things forward. Many of us in ACSED, of course, have been working on these issues and talking with you folks about these things since certainly since the joint project days, and even before that, back to the California Model Employer Initiative days. So we're really pleased that between the legislation and the budget process that hopefully this is all going to come to fruition soon. I guess I had a 2-part question. First of all, as you mentioned, Glenna, one of the things in the bill is that CalHR will now be responsible for reviewing those plans that departments submit to try to improve their hiring of people with disabilities. And you indicated that you are planning to do that and that you'll work with the departments to try to make improvements where that's necessary. But I guess we're kind of curious about if you've decided yet or what you're thinking about what kind of criteria you're going to use to judge whether a department's plan is effective or whether it's one where you need to intervene. And then a related question, another provision in the bill says that you're supposed to take some special attention with those departments that are really seriously deficient and have for many years not made any progress, and ask them to enter into corrective action plans. And in an earlier version of AB 313, we had some criteria in there about how you would determine which departments needed that special scrutiny, but that didn't end up in the final bill. So I guess the second question would be how you're going to determine which departments really need to institute some kind of corrective action plan.
Hi, Ralph. Really great questions. And good to talk with you on this. We haven't talked for a while. I feel like the pandemic has put a little bit of a barrier between some of our conversations that we used to have on this. And we talked extensively back when we spent about a year actually drafting the first policy that was a result of the joint project. And so we had some really great things in there. And I think to go to part of your question, what we will do is something similar where we do want to reach out to ACSED as a stakeholder and get some feedback and suggestions on some of the things that we are putting in the policy so that, we are comprehensive in that policy. We're making sure that it's something that will benefit the departments and something that we can used to hold departments accountable. And so to your question about the criteria, we're in the early stages of that. There's a lot of schools of thought about how to do that. And we have not yet even hired, the people who would be doing it. And one of those positions I'm anticipating at a manager level, and that manager would be very responsible for for the creating that criteria. And again, we're open to our stakeholders giving us some feedback on that. I think as far as how we would hold departments accountable for reaching those goals and those plans, and touching on those departments that haven't, I think you mentioned, haven't been able to do it in years. I think this report that they're requiring is a very good thing, because we will be identifying the departments in the report. And I think that's one thing that we always struggle with, is we want to be a partner with departments and we want to help them reach their goals and to accomplish the things that they need to. But we also struggle with, what are the consequences if you don't? And so, CalHR is an oversight agency, and we do want to hold them accountable, but there aren't very many mechanisms for doing that. And so I'm appreciative of the report portion of AB 313 that will allow us, even if that's just, some leverage that we're using with departments to say, your department will be listed in the report as not being compliant. And we will show what efforts you've made or where the shortcomings are. And so that's what I anticipate as far as reporting and sharing out some of that accountability. But a lot of that really does remain to be determined, just because, again, we don't have the staff. We have not created that criteria. We're in the very early stages of just really excited about finally being able to do that. And but I definitely want all of our stakeholders to know that we're open to meeting and talking with you and hearing what advice you have. And we may not, obviously I report to my director, who reports to the governor, and we have our GovOps agency. So we have a lot of different points of view that will be included in this, and I can't make any guarantees. But I'm thankful that ACSED and Ralph, you and Catherine in particular, have always been very vocal with all of those steps, those layers through the process, so that you can be heard as far as what you think would be helpful for people with disabilities in state service. So I know that didn't give you a lot of precise, exact answers, because I don't have those yet, but I hope that assures you that we're on the same page.
All right, well, thank you. We'll certainly look forward to working with you and trying to flesh out all those issues. Thanks.
Thank you, Ralph. Now we have Scott Richmond next. Scott, please go ahead, unmute, and ask your question.
Hi, Bobby. Can you hear me?
Yes, perfectly. Go ahead, Scott.
Wonderful. Thanks very much, Glenna and Eli, for coming out and answering some questions. I had a couple of follow-up questions relative to the model RA policy, what we've been calling the model RA policy. I kind of gathered from your presentation, Glenna, that there may have been some changes in the policy since we last took a look at it. And that being the case, I was wondering if we could get a look at it and give you folks some input before it was finally released to the state departments. And then I have a second part to the question, and that is the field of reasonable accommodation is fluid, and we've had lots of changes over the last couple of years, and I worry that a lot of departmental policies may not exactly be in step with the times. So I was wondering when and how CalHR might be taking a look at those 88% of the departments that do have a policy and make sure that it's still viable and functional.
Hi, Scott. Thank you. Really great questions. With regard to your first question on the RA policy, Absolutely, we would love to have input from ACSED, and I believe the last time we also had DOR and a few other stakeholders who were kind enough to go through it. And I do remember there were a couple of things that our legal office did not quite let go through because they are attorneys, and so I cannot speak for them and what the final outcome will be after they review the policy. But absolutely, we want all stakeholder input, and so we will reach out as soon as we have a draft completed on our end to ACSED and whoever there would like to take a look and give us any kind of feedback. Not everything that everyone wants will be included. I do see some comments, or one or two in the chat about budget and whether departments would be required to set aside a budget. And I just want to be really honest with that up front. Right now, there's nothing about that in the policy or anticipated to be in the policy, because CalHR, unfortunately can't control department budgets or dictate what they do with their budget. So that would be something that's up to individual departments to work on. And that may be part of their action plan, is to put aside some money if that's where their problems lie, is lacking budget to actually implement effective accommodations. And on your second question, as far as taking a look at policies, you're absolutely right. It is fluid, and that some policies may be very outdated. They may be very generic, and we do worry about that sometimes, because there are so many policies you could just pull up on the internet and just copy it and say, we have a policy, here you go. And we actually also consult a lot with DFEH, because they have a reasonable accommodation form and a whole packet that they use that they say everyone loves. They get a lot of positive feedback on that. So we've used that also to guide us. And so there's not a one size fits all. And so I absolutely agree with you that some of these policies may be too generic. Maybe they don't include everything. I'm hoping our model policy will help them to revamp those and to update them. And we will be following up. The way that that's going to happen, because we don't have someone who's just going to review policies. We don't have a resource that's just dedicated to, having the expertise of reviewing department policies and making sure that they're effective. And we also, can't tell a department very specifically, you're missing this one thing. Or we want you to add 5 new things. We're hoping our model policy will have enough in it that it covers the significant things that we want in a policy. But the way that we'll probably get to whether the policy is effective and is current and works is when we look at that data, and the data that we get every year with the workforce analysis, and we see the numbers. And we will probably have the new staff that we're hiring reaching out to the departments that are the most efficient first. And that's how we'll start to look at that process. And part of looking at those numbers and the fact that they have not been successful in years, they have a very low number of people with disabilities represented at their department. That's when the questions will be asked. Do you have a policy? What does your policy look like? Send us that, let us see your action plan, and all of that will be incorporated together. And it very well may be that they send us, a very outdated policy that doesn't include a lot of the things that it needs. And that's where we're working with them to get that policy updated and as part of their action plan to eventually raise their numbers and their representation of people with disabilities. So that's how I see that playing out, as opposed to, just collecting all the policies and trying to go through, hundreds of them and kind of make CalHR making the decision, for departments, whether they have a good policy or not. It will be based on the representation that they have. And again, with only a small unit, we'll probably start with the most efficient departments on that.
Great, thank you.
Thank you, Glenna. Catherine, go ahead, unmute and ask your question. You're next. Catherine, can you hear us? We cannot hear you. You're still muted if you're speaking.
Can you hear me now?
Now we can. Go ahead,
Okay.
Catherine.
All right. Hello, Glenna. Nice to see you. And yes, as Ralph and others said, we're really excited. ACCED is the co-sponsor for 313. We're very happy to partner with you. And we're being the bona fide agency speaking to issues of disability. We're outside state government, so we hope we can be effective partners and maybe push in areas where you can't so much, but as a partner, we'll increase the disability employment rate overall. So we're looking forward to hearing from you. I understand that you probably at this point don't have strategies for helping departments improve, but two things I wanted to ask about or say. One is, can you give us a timeline? Well, I guess it would be after July, but for approximate timeline for hiring those positions. And also, can you help us know that those will be shared with the SDAC and ACCED so that we can help you do our own disability community outreach and help some qualified applicants with disabilities who might have both lived and professional experience apply for some of those positions. So that's my first question.
Hi, Catherine. Yeah, that's a great question. Absolutely. We will share that information. We have actually, and Eli can attest to this, I've had kind of an all hands on deck strategy as soon as we found out about the positions we're getting. We're also getting positions for other activities as well. So we have quite a few that we'll be getting after July 1st, and we've already started on the duty statements for that. I've kind of enlisted all of my staff and said, I would like everyone's help. Everyone is even going to, effective duty statement training and all of the things that we need to do to really crank out these materials that we need to hire these new individuals. And of course, because CalHR is getting so many positions all at once, we do have a very tiny HR office, and we'll have to stagger some of these recruitments that are going to them. So I can't give a hard and fast date on when the hires will happen, since it's not just OCR and my office and these positions. It's dozens and dozens of positions all coming at once. And so I can't give you a specific date. I want to be honest about that, but I can assure you, and Eli, jump in here if you want to, because I know I've been probably really bugging my staff and even having them come into the office to do working sessions where we're all in a conference room to do these things so that we can create the appropriate duty statements with the duties that we really want related to AB 313 for the couple of positions we got on that. And I don't think, I think we're ahead of the game, to be honest. I'm not sure that the other divisions that have even had an opportunity to start working on that, but we're really excited. And all I can say is we will hire them as quickly as we can. And so that's why we've started already. But as we go along, happy to keep you updated. And again, as soon as we have, materials, we're always happy to share those and get your input. We really appreciate ACCED's, perspective and our partnership.
Yeah, and we want to make sure you get a good candidate pool that does include, qualified people with disabilities. So
Absolutely.
we'd be more than happy to partner with you on that. And then the other thing is, I'm so glad to hear you say that you will be reaching out to ACCED and other stakeholders and to partner and provide. We know we're just providing feedback and that other folks have the final word, but we really value being able to provide that feedback. And just wondering if you can tell us a little bit more what that those efforts for transparency will look like, when we might expect to hear, or what that you'll get. How will that play out in your mind?
Yeah, that's as you said, there are other powers that be. So I, that's something I need to consult with not only my director on, but our chief of legal, who actually is our acting chief deputy right now. Our chief deputy director retired, and so I'm working closely with our chief of legal as our chief deputy director. He and I have already spent some time talking about implementation of AB 313, and so You know, as far as transparency, I want it to be as transparent as it could possibly be. And there's nothing that I'm opposed to as far as sharing, talking, getting that information, relaying that back, you know, to our director, to our legal. I think they're all open to that as well. It's just a matter of their comfort level as far as, you know, what we're implementing and whether they believe CalHR has the authority to do that. Some of it is just semantics. You know, we might do separate documents that we call guidance. And what we really want is, you know, it's like strongly recommended guidance, and we really want departments to follow it, but maybe we just don't have the legal authority to enforce it. And so depending on which things we're talking about and how specific we get into these policies and you know, how we hold departments accountable for their action plans. Some of those things I'll need to discuss, obviously, with my bosses and find out what they envision for that. But as far as coming from the Office of Civil Rights, from Eli and I, we're very transparent, happy to talk to anyone, happy to, you know, let anyone review our documents unless we're told otherwise by, you know, our superiors.
Okay, great. Well, we'll look forward to hearing from you. And I, at least, you know, I think all of us have been so involved in state government that we know how this works, that, you know, we're providing input and advice only, and then it's up to, you know, your department and agency, as you say, up to the governor's office to make the final decision. So we just look forward to being able to provide whatever input we can. So thank you, Glenna.
Thank you so much, Catherine.
For that excellent question, always very insightful. I just have one quick question before I open it up to the chat question, if that's okay with you, Glenna.
Sure.
My question to you is, a couple of months ago, you were at SDAC, and one of the question that came up, and we find this to be a problem oftentimes, is the engagement of interactive process. And I think we mentioned that, is there any plans to engage in interactive process within 5 days of making that request? Is that going to be part of your model policy?
That is a great question, Bobby. And somehow I had a feeling you might ask that. That's something we talk about all the time. You know, the importance of timeliness in a reasonable accommodation process, and a lot of timeliness related issues are going to be discussed in the policy. I cannot, just to be honest, I cannot guarantee that it will say 5 days, only because my legal office will be looking at it, and they may not believe that we can put a specific time frame on that. But Eli, you know, please jump in here. When Eli and I were talking, I tell Eli all the time, 5 days is too long. 5 days is too long to start the interactive process. To me, it should be started, you know, within 24 hours. You get receipt. RAs are a priority. There are people who cannot do their job without a reasonable accommodation. And so what else would be more important than jumping on that and finding out, you know, what needs to be done so that someone could effectively do their job immediately, whether it's a new hire who needs to be successful during their probationary period right from the start, or whether it's an employee, you know, a long-term employee who has a routine and now needs a specific reasonable accommodation, and they can't move forward. Their job just stops because the reasonable accommodation process is taking too long. And so again, I'm not just saying this for SDAC at all. Eli knows that I always lecture on this, and I say 5 days. How about 48 hours? So I am going to try my hardest to put some dates like that in there and see if it gets, you know, through the scrutiny of the layers of the process. And there will be a lot of discussion on the interactive process and the importance of that. That's probably, if, you know, at the top of the the chain as far as important things in that policy, if not the number one thing. At a minimum, we will say immediately acknowledge that you've received the RA. And I have a feeling that maybe, that might be something that we can put in, acknowledge the receipt of the RA within a certain number of days. And again, just my personal opinion, I think 5 days is very, very, very generous. And I worked on RAs for 18 years and never did it take me 5 days to acknowledge receipts. That was something that happened immediately because they were important. Now, that doesn't mean that we can evaluate it, get the information we need, have a complete interactive process, within that 5 days, but that person knows we're going to be reaching out to them very, very soon to get any additional information that we need so that interactive process starts right away. So I hope that raises your comfort level a little bit, that is really important to us. I just can't guarantee the 5 days because I don't know if that will, get through the review process.
We'll take 48 hours, just like.
Trust me, I try stuff all the time. I push it. I don't always get a yes. Sometimes, but it doesn't hurt to try. All they can say is no.
Well, Glenna and Bobby, I do want to share in this particular venue that when we receive that kind of questions from reasonable accommodation professionals in regard to the timelines and in connection with the interactive process, I asked them, I was like, well, did you get the form or did you get the call? Do you understand it? Or do you have any questions? Well, do you have a phone? Do you have email? Contact them now. And if you have any questions in regard to the application, it's a great way to start that dialogue with the individual who may need reasonable accommodation. So we remind the RA professionals that, don't be stuck in regard to these conception of, your deadlines. Think of you want to do it, as soon as reasonably possible. And if you have the means, if you have the time, engage in that process. And I know departments have different processes in regard to the facilitation of the interactive process. So there are various ways that you could do that. But again, as soon as reasonably possible, and, pick up the phone, email or set up a Teams appointment or Zoom, and that could be done.
Well said, Eli. I couldn't agree with you more. These are all great points you made. Thank you so much. And I'm going to open it up for folks in chat. Susan, if you want to read some of the chat questions, that'd be great.
Absolutely. Actually, the first one is a question for Eli. And me and Mindy had the same reaction. Our little activist ears perked up when he heard you said that. You talked about a reasonable accommodation roundtable. And Vin asked in the comments, is the RA roundtable open to the public? And I want to follow up that question with, if it isn't open to the public, can we find out information about what gets discussed in it? Is there any part of that that's public?
Okay, so thank you for that question, and I did want to address that question. So the Reasonable Accommodation Coordinator Roundtable meeting, it's open to reasonable accommodation coordinators, EO officers, or those individuals who directly facilitate the reasonable accommodation process. So we have those individuals that I mentioned as the primary audience for the Reasonable Accommodation Roundtable. So in that particular venue, we have a presentation, we have scenarios, we process, we analyze, we practice with the RA professionals in regard to the interactive process, in regard to analyzing and processing the reasonable accommodation requests. And we also tell them that, work closely with your DACs. So even if at this time it is not open for other individuals outside of those that I mentioned, you as a member of the community of persons with a disability could connect with your EEO officer or with your reasonable accommodation coordinator and engage in that dialogue. We expect them to be the subject matter experts in regard to the facilitation of RA. And so we'd like for them to take, in a way, a collaborative leadership with other individuals in their departments who are advocates of persons with a disability. So hopefully that answers that question.
Thank you so much for your answer, Eli. Yes.
You're welcome.
The next question from Ben is, does the CalHR RA guidelines include recommendations that the department set aside an annual budget for RA expenses? I think this is more than one person asked a similar question.
Yeah, I'll take that one. That was the one that I thought that I saw as I was talking. I was trying to keep track of the questions there. It does not require that, just because department budgets are not part of, anything that CalHR has oversight of. And so certainly we can, recommend things when we're talking to departments on the phone. If anyone ever told us during a consultation that they didn't have the money for something, we would probably fall out of our chair because that's not an acceptable answer. And we say that whenever we've given any kind of training. We say, budget is not an excuse or an acceptable answer for not implementing reasonable accommodation. We don't ever get that that I know of. And Eli, you do more consultations than I do because you get all the mailbox questions, but usually that's not the reason that someone doesn't want to implement a reasonable accommodation. I think by now, after all of these years, departments are very well aware that there's not going to be an undue hardship argument when departments, have millions and millions of dollars in their budget. So I can't remember ever seeing that as a reason for not providing a reasonable accommodation. And again, Eli, feel free to jump in here. But I do understand why people would think that that could be a benefit. Department of Finance would actually have authority over that and have to give the departments, the ability to have kind of a pot of money set aside specifically for that, or a line item, or however that budget works. That's not something that's within CalHR's purview.
And Glenn, I do want to affirm the fact that yes, department RA coordinators are very much cognizant about the fact that if you will present that argument of undue hardship, that the entire state's resources will be factored into that consideration. So in the consultations that I've provided with the departments, the issue in regard to budget hasn't come up. So that's actually reassuring for us. Again, that may be a classic perception or a thought that, okay, well, an RA may not be approved because it may be expensive or so. But again, RA coordinators are very much familiar, with that particular consideration.
That very thorough answer, and that was news to me, so I feel good to hear that. So Joyce asks, I feel reassured that the RA is being sustained and that communication and training is being reinforced on this topic. How do you suggest that departments spread the word to their people on these issues?
That's a really good question, because our customer base is primarily the EEO officers and the reasonable accommodation coordinators. So we're hoping that those people, the EEO officers and RA coordinators, who are sometimes one and the same, are spreading that information as they're giving training and going over policies with their department. But also we report out on these issues at the California Civil Rights Officers meeting, which is every other month, and CalHR has an update at every single meeting at the beginning. And so we share things like implementation of AB 313 and what we're working on and our anticipated timeframes, those types of things. And also we would love if anyone from the department DACs who are attending SDAC would go back and share the information. So it's all of these different communities and different professionals that work on issues related to disabilities and reasonable accommodation that I think really can spread the word. And so I'm hoping, and that's why we're happy to do these presentations. We'd like the information, to get out there to everyone who has an interest in it. And we're open to suggestions if anyone has any ideas on how else we could spread the word.
Thank you, Glenna. Elise asks, is there any recourse for people that were denied a reasonable accommodation?
Absolutely, absolutely. Now, every department, this goes back to department policy. And so our model policy will talk about having a process, of course, that there needs to be information and guidance to employees who, are denied. But departments have different processes. Some of them have a built-in appeal process. So you'll get information that says, your reasonable accommodation has been denied. If you disagree with this, you may take it to your EEO officer or whatever that built-in process is. That is not necessarily my favorite, not to diminish any processes that the departments have. It's just that now that's taking longer for the person to address their reasonable accommodation internally, right? So the biggest recourse is that the State Personnel Board still takes appeals on reasonable accommodation. Even though they stopped taking appeals years ago on other types of discrimination, reasonable accommodation is something that can be appealed through the State Personnel Board, and they do have that information on their website. And the other thing is, we always provide information that there's filing resources through the Department of Fair Employment and Housing and the Equal Employment Opportunity Commission. So we will also have that in our policy that shows that those are the resources as well. We don't want to leave any resource unmentioned to anyone out there who might be having a difficult time getting what they need or knowing where to go. And so appeal is State Personnel Board, and complaints, if you believe that you were denied that reasonable accommodation, inappropriately denied, and you want to file with DFEH or EEOC. And again, some departments also have an internal process, which I can't speak to how effective that is, but your policy should talk about whether or not that's an option to you.
Thank you, Glenna. Wonderful answer. Bobby, we have someone that has their hand raised.
Yeah, so that's going to be our last question. Would it be okay if we get any residual question in the chat that we forwarded to you for a response at a later time?
Absolutely, of course.
Great, thank you so much. So Casey,
Sorry.
go ahead and ask your question, Casey. You're the last person to ask on this segment. Unmute. Casey, you're still muted, and I see your hand up. All right, some reason Casey's not able to speak to us, so please present your question in chat or send us an email, and we will forward that question to Glenna and Eli for their response, along with the rest of the questions that are piled up in our chat. So Glenna and Eli, thank you very much for doing such a wonderful job of showing up here at SDAC and presenting a wealth of information that you have done. You've given us a lot of good, actionable issues to address, and we look forward to working with you closely on this point and see if you could get that 48 hours response time included in your model policy for interactive process. Thank you again.
Thank you so much for having us,
Thank
Bobby.
you.
Thanks.
Thanks, everyone.
Thank you, Eli.